Two things. One, I first want to deal with the stipulation. When the jury returns, the first thing I'm going to advise them of before the argument of counsel will be the following: that the state has submitted a stipulation between the state and the defense in this case. The state has submitted proof at sentencing through the testimony of Deputy Joseph Calhoun regarding 2 tattoos on the body, upper back of the defendant, which says, "Crush your enemy, show no mercy," was present on the defendant when he was taken into custody for these offenses. The stipulation is announced in open court today and memorialized in this written stipulation. So that will be the first thing that I'll deal with. And then to address the various requests for mitigators and wording of the mitigators, I have submitted to each one of the parties a copy of the charge that I intend to give. And I would like to just address the fact that I have considered and read both of the cases that the state has submitted, State versus Hodges and State versus Odom, regarding the non-specific language that is envisioned. My wording of the mitigating circumstances in this case is an attempt to include those mitigators that were fairly raised by the evidence at a sentencing hearing, which but do so in a manner that does not indicate that this court finds those things to be actually established by the proof. I have taken the language of the order or the mitigating factors submitted by the defense and the language of the mitigating factors wording that the state has submitted, and compared that with the language of the mitigating factors instructed in State versus Thomas, 158 Southwest 3rd, 361, pages 402 through 404, a Tennessee Supreme Court decision in 2005. If you review that case, then I think you will find that the language that I have used in the wording of the mitigating circumstances that I have included is in compliance with both the TPI instructions as well as the case law in Odom and Hodges, and in this case that I've just cited to you, because the language of the mitigating circumstances that the trial judge in that court submitted was the following. Question, or the review of the charge submitted to the jury reveals the trial court instructed the jury as to the following mitigating circumstances. 1, whether he was the product of a dysfunctional family subject to abuse. 2, any history of family instability. 3, any proof of abandonment by a significant family member. 4, any evidence to show one of his parents was an abuser of drugs. 5, any difficulty with parents' divorce or separation of parents. 6, any active relationship that he may have had with his child through, although in jail. 7, any proof that shows he has family members that will provide him with love and support while in prison. 8, any proof that although he is in jail, he provides love and support to other members of his family. 9, any positive relationship he has had with other adults and children. And 10, the catch-all, any other mitigating factor. And the Supreme Court upheld that wording of the language and found it to be in compliance with Hodges and Odom. Therefore, the mitigating circumstances that this court will charge are as follows. 1, whether the defendant was the product of a dysfunctional family subject to abuse. 2, any history of childhood psychological, physical, emotional, or sexual abuse. 3, any history of the defendant's neurological conditions or deficiencies and any treatment history or lack of treatment. 4, any proof of the defendant's positive conduct while incarcerated. 5, any proof of the defendant's positive conduct in relationships with others. 6, any proof that shows he has family members that will provide him with love and support while in prison. 7, any active relationship he may have with his child although in jail. 8, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character or record, or any aspect of the circumstances of the offense favorable to the defendant which is supported by the evidence. That last one is the catch-all statutory mitigation. My ruling is based upon the language of the cases that I've reviewed and incorporates all of the ideas that were submitted by both sides, and in my opinion it is in keeping with the statutory inference of the mitigating circumstances in the statute, trying to tailor it to where the language is similar to that so that there's not a clear identification that these were ideas that were found by the court to be facts, but rather they are just simply submitted because they were raised by the evidence. So, having made that ruling, anyone have any, I'm not going to entertain any argument to require me to change my thoughts on this, but is there anything that anyone wants to address on the record about the sentencing charge I intend to give?
Yes. Yes, Your Honor. I just want to, in light of Your Honor's ruling, for purposes of the record, what I'd like to do is introduce as an exhibit in support of our objection the initial charge, draft of the charge that was drafted by the court with the list of 16 mitigators.
All right. I will allow that to be marked as an exhibit for identification purposes for the record to be preserved for the appellate court's review. And we'll note that that was, in fact, a draft of a charge. It was never adopted by this court. It was simply a draft that was the first draft utilizing the 16 mitigators that the defense had proposed, trying to put it in language that this court felt was more akin to what the statute was. And at that point, we had not received the state's response and their proposal. So,
and Your Honor, I will make it clear for the record as a statement by me that as a version of the mitigators that we adopted, having seen that.
right, that's fine. All right, then anything else before we bring the jury in? We are going to allow you to make your closing arguments depending on the timing of that. We may then break for lunch and let me then bring them back after lunch and charge, give them this charge, and that way they haven't started their deliberations before lunch, and we'll let them start right after the charge. It's fairly short by our standards, and so I would like to give them an opportunity to eat their lunch after you've made your closing, if that's possible, and then we'll go ahead and bring them back after lunch, read the final charge and instructions, and then be allowed to begin their deliberations. So we are ready for the jury. We're going to make the stipulation that was entered into an exhibit to these proceedings. I think that would be the appropriate thing to do after I've read it.